5 seconds to go. Start. The learned trial court found accused number 1, accused number 2 and accused number 3 appellant herein guilty of the offences charged with and accordingly sentenced them to undergo life imprisonment for the offence punishable under section 302 read with section 34 IPC. Stop. It further directed them to undergo rigorous imprisonment for different periods for the offences punishable under sections 364, 395, and 201 read with section 34 of the IPC. Stop. The sentences were directly to run concurrently. Stop. Para. Being aggrieved thereby, accused numbers 1 to 3 preferred their respective appeals before the High Court. Stop. The High Court, by the impugned judgment, dismissed the appeals preferred by accused number 1 and accused number 3 appellant herein, but was pleased to allow the appeal preferred by accused number 2, thereby setting aside the judgment of conviction and sentence of the trial court insofar as accused number 2 was concerned. Stop. Para. Being aggrieved thereby, the present appeal. Stop. Para. We have heard Shri R. Basant, learned senior counsel appearing on behalf of the appellant, and Shri K. N. Balagopal, learned senior counsel appearing on behalf of the respondent state of Kerala. Stop. Para. Shri Basant, learned senior counsel would submit that both the trial court and the High Court have erred in convicting and sentencing the appellant for the offences punishable under sections 395, 365, 364, 201, 380, 302 and 302 read with section 34 of the IPC. Stop. He submitted that the prosecution has failed to prove its case against the appellant beyond reasonable doubt and that there are glaring lacunae in the case of the prosecution. Stop. It is submitted that even the High Court found that there were discrepancies in the statements of the prosecution witnesses who were examined during the trial. Stop. It is further submitted that the High Court also observed the glaring discrepancies in the statement of the complainant PW1 with regard to accused number 2 on the basis of which, the High Court acquitted the said accused of all the charges levelled against him. Stop. Para. Shri R. Basant submitted that a memorandum under section 27 of the Indian Evidence Act, 1872, hereinafter referred to as the Evidence Act, is required in cases of recovery initiated at the instance of an accused person, based on the statements made before the police. Stop. It is submitted that, on perusal of evidence on record in the instant matter, neither such memorandum under section 27 of the Evidence Act was prepared at the time of the recovery of the body of deceased, nor were signatures of independent or punch witnesses taken at the time of said recovery. Stop. It is further submitted that it was the duty of the investigating officer for short IO to have prepared the said memorandum while acting on the information obtained from appellant herein, and that such inaction on part of the IO would vitiate the prosecution case, at least insofar as proving the recovery of the dead body of the deceased is concerned. Stop. Para. Shri Basant submitted that the trial court solely relied on the last seen theory and held that the prosecution had proved the same with regard to the chain of circumstances. Stop.